First of all, I'm going to thank everybody for coming tonight. Thank you guys so much. We appreciate you registering and coming. And we'd especially like to thank Beth Polner Abrahams for doing this program for us tonight on elder law. I did not realize what a hot topic this was when we did it, and we got calls all week about it. So thank you so much, Beth. We really appreciate it. Beth, she runs, her law firm is the Polner Abrahams law firm. So yes, it's very kind of her to do this for us tonight. So if you have any questions, guys, you can put them in the chat during the program, or you could just wait till the end. I will allow you guys to unmute at the end. We'll have about a 10-minute question and answer session. And yeah, let's get started. Beth, if you're ready.
Yeah. So again, thank you for letting me share this hour with you. I'm very grateful to be here. I have been an attorney for 40 years, and the last almost 28 to be precise, have been in this field of elder law. My late father called it elder care law, probably more correct, estate planning, and other areas that relate to it, like estate work when someone passes away, and guardianship work for people who are incompetent or incapacitated, and special needs planning. But tonight we're going to focus for 50 minutes on elder law, what you need to know and what you need to not be afraid of. I'm going to share my screen. And start the slideshow. And I believe that this program is being recorded. So I am, as an attorney, required to tell you that you are receiving information. You are not receiving legal advice. I am not allowed to give legal advice except in a client-attorney relationship. And so if you have questions, which we'll take at the very end from the chat room and live, I'll be answering them generally, and you'll see some more information at the end of the program. And so now we can begin. So the program is called Planning Without Fear, Elder Law and Medicaid, What You Need to Know in 2022. And hang on to your hats, because there have been a number of changes and proposed changes. So why do we delay planning? So the realm of elder law, Medicaid, estate, and tax planning, as I said, is changing. So what are some of the origins of I won't do it? So one of them that I think is fear. So fear of aging, and I'll be fine, right? I don't need that, I'll be fine, nothing's gonna happen. In fact, I went to a woman's home a couple of months ago, and I was horrified to see the size of the home, the steps, never mind the legal work that needed to be done. And I asked her, what her plan was if she fell, and her response was, I'm not going to fall, so I'll be fine. Superstition. If I plan, it will happen to me. If I sign a will, I'll surely die. Well, death's inevitable. If I sign a healthcare proxy, which we'll talk about, I will surely get ill. Stories or experiences from the past. So often people come into my office and say, well, 30 years ago, when my mother was in a nursing home, they took everything, right? And 30, 40 years ago, that may have been true, but it's still not a good reason to delay. And probably the only valid reason that people delay, although it shouldn't be a reason, is their fear of the price of legal fees, right? And so the balance against that is, particularly in the world of Medicaid applications, there is a whole group of individuals, including nursing homes, who now prepare applications at no charge. And the saying, you get what you pay for, could not be more aptly applied. We've seen a lot of mistakes as lawyers, and it's of a big concern to statewide for lawyers, for people who use non-lawyers for Medicaid applications without ever having even consulted with a lawyer because they were afraid of legal fees. So before we get into Medicaid, we're going to jump over fear, and the purpose of this presentation is to give you the courage to move forward. So let's start with Medicare just briefly, because the biggest question people ask is, does Medicare pay for care? And when it comes to nursing homes, the answer is yes and no. So you have to be admitted to a hospital, and that's not just a technical term, because there is a very famous case where individuals who thought they were admitted, they thought they were in a hospital room and had been there for at least 3 days. But when it came time for them to leave the hospital and go to a rehabilitation facility in a nursing home, they had been listed as what's called observation status. And the difference between being admitted and having observation status is if you're admitted to a hospital, have a stay of at least 3 days, and then get transferred to a rehab facility, typically in a nursing home, Medicare Part B pays for 20 days in full. And for day 21 through day 100, so another 80 days, Medicare pays all but a certain amount. And in 2022, it's $194.20 per day. But if you were admitted for observation status and surprise on you, you or your family member end up in rehab, Medicare is not going to pay. So always make sure your loved one has been admitted. How do individuals pay for that portion that Medicare doesn't pay for? Most people have a Medicare supplement that they have purchased that pays for this copay. Now, what about at home or in home? So Medicare pays for what's called rehabilitative services at home. The services have to be necessary for maintenance. In other words, you don't have to improve, it's for maintenance. Speech therapy, physical therapy, occupational therapy. After a hospital stay, you'll get limited home care. You'll get a personal aide who will come in 2 hours a day, 2 or 3 times a week for bathing, maybe for 3 weeks tops. It's only if you require skilled nursing care or skilled therapy at home that it might be extended. It requires a doctor's prescription and it can be renewed. And those sorts of services are delivered not by an agency called a companion agency, but by a particular licensed agency called a CHA, a Certified Home Health Agency. So we enter now Medicaid. And there's a lot of what's going on, only some of which we have time to touch on. So I call it the new world of Medicaid. And it's going to affect, if proposals go into place, some have already, what services are given to the person who qualifies for Medicaid financially, how those services come to you, who determines how much services you get, and a brand new aspect for home care, which may go into effect in July, called a look back. The look back is a phrase we'll talk about. Everyone seems to know and have heard about the nursing home look back called the 5-year look back. But the proposal that was put into place by former Governor Cuomo about right around the time of the pandemic was called the 30-month look back. So how are care services, home care delivered is, as I said, changing. So let's look at first what we have now. So we will talk about how you get Medicaid, but after Medicaid issues a notice accepting the application as opening your case, you call a contract agency. It's a phone number. The lawyer gives it to you, and they schedule a contract nurse to visit. And during this time, they're using telehealth and Zoom to visit with the individual who's ill at home. And that lasts 2 to 3 hours. And as I said, it can be virtual. We encourage family members to be present. If you're currently paying for an aide, you don't want the aide to be the sole person giving information to the nurse. And the nurse goes through the medical information, medication, and the key phrase, the activities of daily living that let's say the senior needs assistance with. And all of this information is put into a database, and the family member then, at the conclusion of the nursing assessment, calls the same contract agency, and they put out on the computer who wants this case to something called an MLTC, a Managed Long-Term Care Agency. Then the agency that picks it up, the MLT social worker or nurse, visits or by telehealth, informs the family, having seen the data of the number of hours and days per week that they will give for home health aides typically. Now, I've seen families, I've coached them to advocate for more days and hours, and that goes into the role of the lawyer in preparing the family for this interview. In other words, it's not enough just to get Medicaid if you're not going to get sufficient hours. The senior or their representative signs the enrollment forms, think almost like, regular health insurance, and services begin the first of the following month. There's a hitch. All enrollments must be no later than the 20th of the month to begin on the first of the following month. There is a lecture in and of itself about how to increase hours, what happens if you need to change MLTCs, what happens if you're not happy with the home care aide or agency that's delivering the services, and what your rights are when you receive a notice they're going to decrease services. So just be aware that you would need an advocate, generally a lawyer. There is an organization that provides guidance through trained paralegals called Nassau Suffolk Law Services Committee on Long Island. And they also provide guidance for you to self-advocate. Now, here's the problem. Originally, we thought starting in this month, January 2022, now we're not sure. It might be April 2022, as the slide says. It could be pushed out to the summer. New York State's proposing that a contract physician, not your personal doctor, will be part of the process to evaluate the need for home care services. Now, this comes up because your personal physician fills in a general medical form, certifying your diagnoses, and often we use detailed information from physicians as to the need for services so that we can get more home care hours. So this is going to be a problem. We think that contract physician might do the assessment. We don't know if it's going to be in person or telehealth. We don't know how they're going to handle the exchange of medical records. And so we're hoping that this either doesn't go through in terms of operation and just remains on the books, or that once New York State issues what's called guidance or regulations, we'll have more information. Personally, I don't think it's going to start till July 2022, but stay tuned and we'll find out. The other concern is that for persons who need more than 12 hours per day. So the way that you get services is they determine your need based on tasks, and we're going to talk about that later in the program. And on average, an individual generally qualifies for 6 to 8 hours per day, 5 to 7 days per week. But it is possible that an individual might qualify for 10 to 12 hours. Well, what happens if someone needs someone to sleep in, or what we call split shift care, more than 12 hours per day? They've given them a label as high hour consumers, and it triggers an independent assessment. And that is of concern, because the concern is, the standard is, whether the individual is capable of safely remaining in the community. And that should be triggering bells, because if they determine you can't live safely in the community, where are you going to go? Are you going to go to a nursing home? Are you going to go to assisted living? Do you have the means to pay for assisted living, etc.? So again, stay tuned. And then coming in July 2022, assuming that New York State gets permission from the federal government, the agency called CMS, their proposal is to create a look back period for Medicaid home care. So we're going to look at what this means and review how you become eligible for Medicaid for home care services. So first of all, what is a look back period? So a look back has two meanings. The first is it is unexplained transfers or gifts of resources to someone who's not what we call a permissible person, someone who wouldn't normally be getting this as a right under law, like a spouse, within a period of time. So for nursing home care, it has been 5 years since 2006. So if I give away assets and within that 5 years, I need nursing home care, I'm not going to get Medicaid because the gift happened within the look back. The look back period for home care and nursing home care is also the quantity of documentation that I must provide. If I apply for nursing home care, I have to show them 60 months of financial statements. And so what they want to do with home care is to create not only a look back of 30 months, but also to require documentation for 30 months. Most people who apply for home care need it rather quickly. And they need it rather quickly because something has happened, whether it's a fall, a discharge from a hospital, the realization of family that mom or dad is not safe because they have cognitive impairments and they're knocking around the house. So the look back delays the processing of home care applications. So the good news is, as I said before, that for home care, the look back is on hold. And the only other thing that most attorneys are telling clients is, it's if you're going to consider transfers because you need home care, it's probably best to get it done by April 2022, perhaps July 2022, because currently there's no look back in home care. And when there's no look back, it means there's no what we call penalty or waiting period. That's what we have right now. So what's the takeaway from this what's going to happen slide? The takeaway is it's important to have a consultation with a qualified elder law attorney to understand your personalized options for how to approach transfers and what the look back law is at the time you need home care, including nursing home care, and how to manage those transfers. So speaking of transfers, what is this about transfers or gifting, as we call it? So whether it's home care, if the law goes into effect, or nursing home care, for which we've always had a look back, it's important to review persons who are allowed to what we call receive gifts or transfers from the individual who needs Medicaid. And these we call generally permissible persons. So who are permissible persons to receive these transfers or gifts? So between a married couple, transfers of anything at any time can be made between them. And there will never be what's called a waiting period or a penalty period. And what that means is if I need nursing home care in February and I still have certain assets in my name that would disqualify me from Medicaid, I can transfer them to my spouse in January, and I can still get Medicaid in February. For nursing home care, I will still have a look back period, but the transfer is legal. You can also make transfers of any resource to an adult disabled child under age 65. Adult means someone over 18. Disabled means a person who's receiving Social Security disability or SSI. But again, they may not be able to manage money by virtue of their disability and may need a special needs trust. Speak to an attorney. Nursing home care, very special carve-outs. An individual can transfer their home to a caregiver child who has lived with them for at least 2 years before nursing home placement. So if I have a 2-family home or a single family home and one of my children lives with me and has been helping me. Maybe they've been taking care of the lawn, the snow shoveling, the repairs, the food shopping, the home cleaning. Maybe they've been doing hands-on care for me, and they've lived with me for at least 2 years. I can transfer the home to them even at the last minute, and I can still qualify for nursing home care. We don't know if this exception is going to transfer over to the home care program if the new laws go through. And so if doing some Medicaid planning, even before you need home care, which we'll talk about at the end of the program, is important to you, you might need to consider whether it should be done at least before July 2022. Who are other permissible persons? Well, we have an interesting one, the transfer of a home to a sibling who has lived with the Medicaid applicant for at least 1 year and has some equity ownership in the home. So if I have a home and I'm living with my brother and he owns 2% of the home, 50% of the home, it doesn't matter. He has an ownership interest and he has lived with me for 1 year. He doesn't have to have helped take care of me. He simply has to have lived there for 1 year, 12 full months. And I need Medicaid. I could give him the home by deed and I can still get Medicaid. And you can transfer a home to a minor child under age 21. The child does not have to live in the home. There are other considerations we have to take care of. So always when you're giving something to a child, particularly under 18, but even between 18 and 21, it's important to speak with an elder law attorney. So now that we know what we can give away, let's find out what you can own and still get Medicaid. So we're going to first look at resources. So what can be owned by the person who needs Medicaid? So we call that person the applicant. And this doesn't matter whether the individual is applying for home care or nursing home care. So in 2022, the individual can have up to $16,800 in what we call cash or liquid assets. They may also own term life or group insurance, and that's because that has no value until you're dead. They can certainly have a burial plot and a prepaid, what's called irrevocable burial contract or burial fund. Now, if they're married, and this is a bizarre part of the law, the home that the person lives in or their spouse lives in, right, if they're in a nursing home, is completely not counted. And we call that no cap on equity value. IRAs are not counted as long as their Medicaid doesn't use the term RMD, as long as they're in pay status. In pay status means that the individual is taking their distributions. But under Medicaid rules, if you're married, Medicaid says the RMD is what the Internal Revenue Service determines. If you're not married, because you're single, widowed, divorced, there's a different table that has to be used, and it's called a Medicaid table. Now, annuities and IRA annuities have strict rules with special rules to be non-countable. They are not good for Medicaid. Many years ago, they were okay. And unfortunately, because we use them as a Medicaid planning strategy, what do you think happened? The law changed. So if an annuity is owned by an applicant, the annuity must be paying out like an IRA. But if the annuity started paying out after February of 2006, not only does it have to be paying out like an IRA, but New York State must be named as the beneficiary. Unless they're married, then the spouse can be first and Medicaid can be second. So annuities present problems. Ownership of annuities can be a wonderful thing for an individual, for investments, etc. But if you're thinking about Medicaid planning, it's a good idea to consult with an attorney. Now, I talked about the cap, the equity cap. So remember, if you're a married couple and you're both living in the home, one of you or both of you are on Medicaid for home care, the value of the home doesn't count. If one of you is in a nursing home and your spouse is living in the home, then you don't have to worry about the value of the home. But if you're unmarried and you live in the home, for example, for home care services, there's an equity cap. So in 2022, the equity cap is $955,000. What does equity cap mean? It means that if your home is valued at $1 million and the cap is $955,000, you'll have to take out a loan to reduce the value of your home, the equity in your home, to bring it to the Medicaid permissible level. Now, if the home is vacant under Medicaid rules, the home is considered a resource, unless it's fairly complicated, but unless there's a caretaker child living there, a minor child, et cetera, then there's some wiggle room for protecting the home, but it may become subject to Medicaid liens, so always consult with an elder law attorney. So if the applicant owns any other resources other than what we just described, then they're not going to be eligible for Medicaid unless the assets are transferred, whether or not there's a penalty period, or spent down on care. And we'll come back to that. So if the individual is married, what can the spouse keep, right? So on nursing home care and home care, we have a blending of rules. And so far, that hasn't changed. So the rule for nursing home that can be used in home care is Medicaid wants the spouse to have a certain amount of cash, we'll call it, cash, investments, property. So it's called the resource allowance for the spouse. And in 2022, you can have up to $137,400. The spouse can also have other non-countable resources. They can have their own IRA. And if it's in pay status, they're good, it's not counted, regardless of the value. They can have term life insurance. They can certainly own their home if they're living in it, right? That's what a homestead is. They can have a prepaid funeral arrangement. Anything more than that means the spouse will submit a spousal refusal. So what is a spousal refusal? It's a written statement that is submitted at the time of application, whether for home care or nursing home care, that says that you're refusing to contribute excess income or excess resources, which is what we're talking about right now, towards your spouse's care. It's legal in New York State. But spousal refusal means Medicaid can demand repayment at the Medicaid rate for the care it pays for your spouse. It would be ridiculous, in fact, to be afraid to apply for nursing home care and to instead privately pay rather than submit a spousal refusal statement, because when they seek repayment, what's deducted, they start with, the Medicaid rate for a facility. And statistically, Medicaid rates are about half the cost of what private pay is. And they subtract from that what's already been paid. And that would be the monthly income that an applicant or recipient, once it's accepted, is required to pay to the nursing home. So spousal refusal is a very, very important right. So let's talk about income, Medicaid and income. So the rules for the Medicaid recipient and their spouse, if any, for home care is very complex. And there are choices to be made, and only a qualified elder law attorney can advise you on those choices. There may be some new rules in coming up in either April or July for income, but we don't know whether they'll be adopted. So looking at the rules we have now on home care, and nursing home care. Medicaid has rules about what income the applicant can keep. The rules are different depending on whether you're married or unmarried. And the rules are complex when you're married because under the home care program currently, only a lawyer can analyze whether you should use what are called the home care rules or the nursing home rules. So what is income? It's Social Security, IRA distributions, pensions, interest, dividends, net rents for rental properties, business income, even for people who get Medicare Part B premium reimbursement. Now, most types of income, like what I just described, are countable. And another important thing is Medicaid looks at gross income, not net. So we often have to counsel clients that if they have a pension that they have taxes withheld, or Social Security where they have taxes withheld, we have to tell them to stop the withholding. So with nursing home care, generally all of the income of the nursing home applicant or recipient is paid to the nursing home, except $50 a month. Now there's a special rule if you're married, and that's because Medicaid wants to make sure that the spouse in the community has a minimum amount of income. And the new minimum for 2022 is $3,435. There's an example on the slide, and in that example, basically, it looks at a nursing home spouse, the one who's in the nursing home, having $3,700 a month. And if the community spouse, the one who's not in the nursing home, has income that's lower, $1,250 in my example, they do a math problem. They look at what they want the individual to have, $3,435. They subtract what he or she already has, and they come up with the amount of the deficit. And so from the nursing home spouse's income, that deficit will be directed over that $2,185 to the individual in the community. And so there's a smaller balance that goes to the nursing home. And the term for the amount that goes to the nursing home is called NAMI. Now, if the individual is in a nursing home, as I said, and we're talking about a single person, they're, as I said before, just like the married person, they're allowed to keep a small allowance, $50 a month. If they pay for a supplement, a Medicare supplement, they can also keep enough money to pay for that. And I give you an example on the slide. $3,700 a month income minus $50 a month minus the cost of a Medicare premium leaves a certain amount that the nursing home will get as the applicant recipient's NAMI. Now in home care, it's a little more convoluted, but it works. And we are concerned that this rule will change. The applicant is allowed to keep, because they're living in their community, they're living in their home, $934 a month in 2022. And just like in a nursing home, if they pay for a supplemental Medicare policy and a drug plan, they get to keep sufficient income to continue that. So what happens if they have more income than $934, which is called excess income or spend down? So this is what we're worried about. It's a great option now. They can place their income into something called a pooled income community trust. It's not written by a lawyer. It's administered and created by a not-for-profit. We've been using them for probably 20 years now. The senior joins the pool trust. The lawyer usually fills in the form for them called a joining agreement. The income is taken electronically from the senior's account based upon what they have as excess income. The senior picks the date it's going to go up to their account at the not-for-profit pool trust, and then they send the not-for-profit bills, and the not-for-profit pays those bills. So instead of spending down their income, like in the old days when I first started on home care until Medicaid kicked in a month, they have this income that they can send bills to the not-for-profit to pay the bills to keep them in the community. and Medicaid pays in full for the care. Now, again, if this option is shut down, it's going to be devastating, not just for singles, but married couples who want to stay home rather than in nursing home placement. And this is a serious concern among legal advocates. And we continue to urge individuals to contact their New York State legislative representatives to let them know that you want New York State to keep pooled income trusts in place. Now, in terms of nursing home spousal income and resource rules, as I said before, we use a variation on this in the home care arena. I'm not going to spend much time on this slide, but you should know that one of the other roles that a qualified elder law attorney plays is in doing the analysis of, is it better for this family to protect more resources, more assets, and forego some monthly income, or to use the pooled trust, or to use what's called traditional Medicaid home care budgeting, which is something we traditionally don't use because what you can keep is so low. So the purpose of this slide is to introduce the complexity and the thought process that goes by a lawyer only, that goes into selecting how do you present the Medicaid home care application in terms of income. Okay, so we've talked about resources and how we qualify an individual for Medicaid for home care and nursing home care. But I'm going to focus on home care for a moment because it's important to understand what services are deliverable. So Medicaid, once it's accepted, their role is ended. And as we talked about, a nurse comes and does an assessment. So mostly what individuals are looking for is something called personal care aides or home health aides. And it's not arbitrary what they can do. It's very strictly defined in regulation. So for example, what would a home care aide be able to do? I like to think of it as an individual opens their eyes in the morning and then what? And that's how we break it down. Think about what you do and you take for granted if you're healthy and well. You sit up in the bed, you swing your legs over, your feet go on the floor, you rise from the bed, you walk into your toilet, for example, you do your business, you turn around, you wash your hands, you walk back. Those are all tasks. And where someone can't do those things is where personal care aides come in. Now, one of the things that personal care aides can't do is they cannot administer medication. So usually family has to set up the box for the pills. The aide can put the medication in the individual's hand, but they cannot put it into their mouth. Various therapies. So to the extent that Medicare won't pay for certain therapies, Medicaid can pay for them. The PERS, the Personal Emergency Response System, Lifeline, I've fallen and I can't get up. Medicaid pays for that because there are seniors who need assistance. They don't need someone to live in, but there's a risk for falling. And so Medicaid pays for that monthly charge. Meal delivery, nursing, daycare. It's called social model daycare for the frail and individuals with dementia. Unfortunately, during COVID, many of these programs, including the one in my community where I'm an active participant and volunteer, have shut down. And this has caused a great deal of problems for families. Think of it as children in daycare. It's the same thing for seniors. But these are wonderful programs. And if we ever resume a regular world, it's a great place for seniors with who are frail or with dementia. They pay for equipment to the extent Medicare doesn't. They pay for adult incontinence supplies, diapers, a certain type. They don't pay for chucks, and they don't pay for gloves, and they don't pay for lotions. And they pay for transportation. What does that mean? Generally, it means by ambulette. So someone has to go to dialysis, and the only way they can be transported is by ambulette. There's a budget line for that transport. So going back to no delay in planning for Medicaid, right? You know, what's the fear, et cetera. So what can you do to plan in advance for Medicaid for home care if we have a look back, and nursing home care where we do have a look back? And are there options if you haven't planned in advance? So one of the most important legal documents that you can have is called a power of attorney. It's a legal document for financial management, for when you're not able to make financial decisions, pay bills, take care of your assets and property, or even if you can do it and you've signed this document, you want someone else to do it for you, called your agent, right? So the law and the form changed in June of 2021, smack dab during the COVID, and we were inundated with questions. And so the first question is your existing power of attorney still valid? And yes, your existing document is still valid if it was properly done, but review your document to make sure the powers that you're and the authority that you're giving your power of attorney, your agent, fit your needs now. Make sure your agents are still people you trust, and make sure the powers are comprehensive. And if you want it, allow for Medicaid planning for yourself in the future. It's very well settled that a very detailed power of attorney that allows for gifting and lays it out in detail, including changing beneficiaries, fixing IRAs to make them Medicaid compliant, that even if you don't want to do anything to the last minute, it's your power of attorney with that authority in detail that will allow Medicaid to be accessed. An irrevocable living trust. Your power of attorney could give your agent the authority to create an irrevocable living trust. But what if you're competent now? So one of the most common tools for protecting resources before you need Medicaid, whether it's going to be home care if that law goes into effect with look back, but mostly used for the last 30 years for nursing home care, is the irrevocable living trust. It preserves income and gift tax exclusions on assets in the trust. A lawyer must draft the trust document, and average fees have a huge range. You can see, I've seen fees of $4,500 on up to $15,000. Generally, that depends on what other legal documents are prepared as part of the elder law plan. When you do an irrevocable trust, think of a bowl sitting on a table. And once you create that trust, you have to fill the bowl. And once you fill the bowl, your penalty period, your look back starts. So if I create a trust and sign it in January, and I am going to put my home into the trust in January, then my bowl is filled in January and my penalty clock starts, my 5-year waiting period for nursing home care, in February. So if I'm doing this in 2022, I cannot get Medicaid till the end of February 2027. Anything can be transferred to a trust, an irrevocable living trust, a home, condo, a rental property, a vacation home, investment account, stock, even a stream of income from a business, out-of-state property, vacant land. And the only cautionary note is that many cooperatives generally decline or refuse the transfer of shares. In the town of Oyster Bay, they still allow it for town properties. And so before you pay for an irrevocable trust, make sure that you check out with your management company whether it's going to be permitted before you pay for the legal work. Another very common pre-planning Medicaid tool, including with home care, is what's called the life estate deed. Some people just don't feel comfortable transferring their home or property, real estate, to a trust. And so there's something called a life estate deed. And that's where you're transferring real estate to a family member or more than one now, and you or you and your spouse retain the right to live in the property for your lifetime. Now, a life estate means that you keep all income and net profits for your lifetime. So if it happens to be rental property, it's you who still get the rental income. But income also has another definition. It's a right which keeps, for example, veterans benefits, reductions, on the real estate, the star and the enhanced star. Now, a life estate deed, in other words, transferring property and keeping a life estate, is considered a transfer or a gift and could be subject to the 5-year nursing home look-back rule, perhaps the home care rule if it goes into effect, unless the home is deeded to a permissible person. So, for example, if my son lives with me and has lived with me for 2 years, I will probably give him the house and retain a life estate. Why would I keep a life estate? Because I get enhanced star if I'm a low income senior, or my spouse was a veteran and my taxes are low because I get the veterans exemption. There are negatives for a life estate deed. If the house is sold while you are living, even if you're on Medicaid in a nursing home, you will receive some of the sale proceeds, and that will disqualify you from Medicaid. The other risk is if the home is empty because you were the only one living there and it's sitting there, and one of the individuals in your family who received the home, subject to your life estate, and we call those remaindermen, if they declare bankruptcy and the home is empty, that home is eventually going to get sold. And again, your life estate proceeds will go to the nursing home or an arrangement will be made to repay Medicaid. So there are some very good reasons to do a life estate, and there are some very serious negative reasons. And again, that's discussed with a qualified elder law attorney. So one of the last options is what we call crisis Medicaid planning. And I don't know that this will apply in home care, but it currently applies in nursing home care. Let's say you did a really good power of attorney. And with that really good power of attorney, you said at the last minute gifts could be made. So the way that we make gifts at the last minute is called a promissory note plan, or sometimes it's called a loan and gift. And basically, when someone doesn't have a permissible person to give assets to, a lawyer drafts up a contract that says, I've received from you this amount of money. I'm going to pay you back a certain amount of money for a certain period of time. And at the end of that time, I'm going to get full Medicaid. It's very complicated. The amount that's preserved as the gift is about 40% of the amount that was transferred. And again, it must be done by a lawyer. Finally, we have the Revocable Living Trust. And the only reason I mention this is to remind individuals that a Revocable Living Trust is also a legal document that must be prepared by a lawyer. And it serves some really excellent functions that we don't have time to discuss here, but it does not protect assets or the home from any Medicaid claims unless there's another law that protects the assets in the trust. So if I have a revocable trust and I put my stock portfolio in it and I try and get Medicaid, revocable means that I still own it and I will not get Medicaid. There are certain exceptions with the deed, but a revocable living trust, again, which has value, just may not be a good idea when it comes to Medicaid planning. And finally, I have to say, I would be remiss that the other important document in any elder care plan is the healthcare proxy. And the document does not require a lawyer. It's witnessed by 2 people who are not your healthcare agents. You can get the form from your doctor, from the New York State Bar Association website, from the New York State Department of Health website, or if you're doing planning with a lawyer. When you lack the medical ability to communicate your decisions, particularly if you're living in the community, someone has to be your medical voice, and that's the healthcare proxy. And as you can see from the slide, they make many different types of decisions once a doctor certifies that you're unable to do so. It's not just end of life. Surgery, biopsies, anesthesia, medication, all the way through end of life decisions. So the best plan is to take time for elder law advice and counsel with a qualified elder law attorney and determine what personalized planning is needed. And as I said at the beginning, fear should not be your motivator, but should also not prevent you from planning. Control of your life, your age, and your decisions should be paramount.